Hey everybody, Shel Broadnax here with another episode of Stage Your Talk, and I'm super excited today because we have a RESA Connect speaker. Her name is Angie Avard Turner, and she's an attorney out of Georgia. Thank you for joining us.
Thank you for having me.
And we're super excited because you're going to talk about protecting your business, protecting your creative ideas. Angie is specifically niched into the creative field of being an attorney because she's been a designer and an artist and understands licensing agreements. And it's just such a wealth of knowledge in the creative field. I think it's really important that we have somebody like Angie that can answer these specific questions that we have coming forward. So at RESA Connect, we're going to talk about protecting your works. And we talked a little bit earlier privately about trademarks. Contracts are so important for stagers. We even talked about 1099 versus W-2 employees. All of it is just so expensive, or not expensive, so important and well worth the investment in your business to protect your work. What would you say is probably, if somebody was going to hone in on one thing or the other, what would be the most important that somebody would be looking at in a creative aspect for a stager?
That's a good question. I would say, I don't know if I can narrow it down to just one.
I know they're all important. People ask me that. I'm like, it's everything or nothing.
Yeah, I know. I mean, if I were going to prioritize it, if it was a person who was just starting out a staging business, because, right, I mean, like everything's not important at the same time, so when you're, a baby business, getting incorporated is really forefront. You want to protect whatever you have personally and separate it out from whatever it is that you're doing on a professional level. So I would say if you were just starting out or getting ready to start a new business, that would be something, because that's the sort of the legal foundation. You're laying the foundation, you're creating your business entity, which becomes almost like another child that you're nurturing and growing. And so I would say if you're just starting out, that might be the most important thing. If you've been in business for a while, you probably have already taken that step, hopefully. And so that might not be in the forefront. And maybe, tightening up your agreements or making sure that you have them, or, making sure your website's compliant with certain rules and regulations. Underlying sort of all of those things, you want to make sure that you're protecting your brand name. Because there's nothing worse than operating with a name and then receiving a letter that says like, hey, we were operating with that name before you were, and now you're going to have to stop. So, I would say alongside with incorporating and creating your business entity, I would say trademarking your name would sort of be, those two to me they're kind of first cousins. They go together.
Yeah, definitely. So what about if the name is not local? So often I have stagers call me that says, hey, my business name is Staging to Sell, the most common business name for stagers. And I'm in Alameda, California, and somebody else is in Houston, Texas, and they have that. And I had it first. And it's like.
Right. Yeah, so that happens quite a bit across many creative industries. And so what happens is it, if it hasn't been protected and you are able to protect whatever that phrase is or whatever those words are, then you should. If someone already has it registered and you've been using it, let's say, if someone has registered it, let's say they registered that mark in 2022, but you've been operating since 2018. If that's the case, then it's possible that you could continue to use that mark, but you would be limited to the geographic area that you're in. You wouldn't be able to expand beyond whatever that, specific geographic area is. There's a great case about that involves Burger King, and it spells that rule out perfectly.
So for stagers that mostly are working in a local geographic area, is it really a big deal? I probably know over the last 23 years, I could probably name 20 Staging to Sell type companies with that in their name, right, that are spread out all over the place, but they're not in competition with each other. There's no risk of them being mistaken for each other.
Right. Well, again, it depends on when they began using whatever the mark is. It depends on who may or may not have it, whoever has it registered or something similar registered. It depends on whoever that person is, whoever that business is that has it registered. How litigious are they? Like, how willing are they to go after other, I mean, I can sit here and say just in the abstract, like, okay, well, so and so over here in this city and state can use it, and so over here in this city and state, 3 or 4 states away should be able to use it because they're sort of operating in limited regional areas. But it boils down to, if this person over here who has it registered wants to be super aggressive about it, then, they can always find that attorney that's willing to be aggressive about it alongside them, and push it. But at the end of the day, if someone's had prior use, even if they haven't registered the mark, as long as they're operating in that, in the region that they're in, let's say they're in Dallas and they've been operating there since 2015, and someone comes along from Illinois, Chicago, and is like, hey, I registered this mark. Well, and we registered in 2020, and this person's been around since 2015. Then, the person in Illinois is going to have the ability, if they want to expand that business beyond Illinois. And the law will back that up. But they can't just make the person who has been operating in Dallas since 2015 completely shut down.
Gotcha.
The business in Dallas won't be able to expand beyond Dallas. And maybe they don't care, that happens all the time.
Definitely. Now, contracts, I know it is definitely something in our industry that new people often operate without a contract, which is very dangerous, in my opinion. We make contracts available. Our attorneys have made contracts available for our members. And we have a program where they can actually meet with somebody to go over the ins and outs of it, specify it to their particular business, so they make sure they understand it as well.
Right.
But so many people get these templates, just contract templates off websites, or they share them and they're not even really looking them or understanding the language.
Right.
You touch on how really important it is for somebody to have a solid contract. And I think a lot of people have this misnomer that contracts, some don't want them very long. They want them short, but they don't contain everything. And they think that a longer one is going to be overwhelming to somebody and they won't sign it. I don't subscribe to that thought, but I think it makes you look more professional. And the contract's there to protect everybody, just so you have a meeting of the minds on paper of what's going to happen. But for some reason, contracts, like, they have a bad name with some people, and where they don't use them. What's up with that aspect?
Yeah. And I think I think you're right. I deal with that literally on, if not daily, at least weekly basis with clients, or with somebody that my clients are dealing with. And, contracts, it sometimes feels like people perceive them as a 4-letter word, and they really are not. Really, in my opinion, what they boil down to is one side and another side getting together and putting down on paper, okay, this is what we agree about, and this is how we're going to operate. Whether it's an employer, whether it's, a certain business and a client, it's just memorializing, like, okay, this is how this relationship is going to happen. And the best time to do it is when everybody's reading off the same page, literally and figuratively. Like, you don't want to have that conversation after you've entered into a conflict. Too late. You want to do it when everybody's in agreement and everybody's like smiling and, okay, yeah, sure, we'll agree to that. Okay, sure, we will too, and that's the best time to have those conversations, and that's usually when people don't want to have them, because they're like, oh, we're fine. Of course we're going to, nothing's going to happen.
Yeah.
They're a friend. I've heard that so many times, like, oh, this is a friend of my, sisters or whatever. And then something goes sideways, and then they wish they had it. Another thing that happens is like you were alluding to is, oh, I don't want that contract to be too long because that's intimidating and I don't want to scare anybody off. And I'm telling you, like, I've written contracts where, they'll be, the shorter ones are 3 to 5 pages. The longer ones are 10 or more. Right. And so, they'll come back to me and they're like, can we shorten this? I'm like, sure. Would you like less protection? They're like, no. I'm like, okay, then no. I just make it really simple, and I'm not trying to be, smart aleck about it, but I'm just being honest. Like, if it's in there for a reason. And what I try to counsel my clients on is, it's in there for a reason. So here, let me help you get comfortable with whatever it is it says. Because if you're comfortable and you're confident about what's in your contract, which means you actually know what's in it, then
right,
you can talk to the person on the other side and say, like, hey, well, this is why this is in here. And it's not all about me, it's about us. And how do we get this worked out and signed, as opposed to like, I'm going to try to railroad something through. And that does happen where, there's one side and, the attorney, whoever it is, writes it so one-sided that it's like, did you actually want them to work together? Because, it's like so one-sided. It's like hard to sort of come back in good faith and feel like, oh, we're gonna be able to work this out and be on sort of equal footing. But, that's what
Yeah.
the contracts are for, though. And
Yeah.
another thing that I run into is once the contract's written, it's like it's set in stone, and yes, in a sense, it is meant to be in black and white, but it is oftentimes meant to be a living document that, okay, we've worked together for 6 months or we've worked together for, a year. And does this still reflect the relationship that we have or that we want to have? If not, then let's go back to the drawing board and figure out what works best. You always want to have that type of open communication using those types of instruments and documents so that you're already out ahead of a potential problem. The worst place to be is you haven't had those conversations or you don't have those documents and now you're having to be reactive.
Yeah.
Because then it automatically puts you on the defensive. It's not where anybody wants to be.
Yeah, absolutely. Now, I think a lot of stagers too, we're trying to teach them more and more these days now about having subcontractor agreements.
Yes.
So it's so important to be able to have those arrangements with people that you use and making sure that they're licensed and that they are insured. And, if they have employees, they have workers' comp and
Right.
all of that information too, that I think stagers just don't think about.
Sure. Yeah. Well, and, nobody wants to be negative and nobody wants to think about the worst case scenario. But the reality is sometimes we have to think about that, and if you can get comfortable with like, okay, what's the worst thing that could happen? Now, how do I protect against that? Once you figured that out, like you can protect against it and then move on, knowing that, okay, well, I can't prevent all bad things from happening, but if bad things do happen or things that don't go quite my way, then I have things in place that will protect me or that will take care of it,
Yeah, absolutely. We know the one of the examples that we use with the subcontractors is that a lot of these college hunks and trucks or college hunks haul junk or
Yeah.
these types of companies are mostly franchisees, owner operated. They don't have to have workers' comp. They don't have employees, and it's just owner operator people. Those people come onto your client's property. Worst case scenario, they're literally moving furniture around. They trip on the step.
Yeah.
Now it's a fast fight. Even if they have health insurance,
Right.
they're going to want to subrogate a claim.
Right.
And so people don't understand with that how important it is to be able to make sure that they have these types of coverages, because it's going to be a race where that person says, yeah, I have health insurance, but as soon as you walk in the emergency room, did this happen? Was it an accident? Who's responsible? That's why they're asking that information, so your insurance can subrogate it.
Well, and I try to teach my clients protection works best in layers. If you can get one layer of protection, which usually means you have insurance or you have some sort of agreement, great. Or you have a trademark registered, or you have, your copyrights registered, whatever it is, great. If you can get whoever the person is that may be a W-9 contractor or a subcontractor, like those people, the next layer of protection, right? Like, great. Then, hopefully the people that you're working for, they also, if you're going on their property, they have protection. So all these things work in connection with one another. But when someone doesn't have protection, then the burden shifts to somebody else. And that's where it gets really can get a little tricky.
It's a little tricky, especially when you're dealing with the client that you spent so much time trying to get.
Yes.
To make an error, a lapse in judgment of that. It's just, you step in it and it's hard to get off at that point because they need to be able to trust you.
Right. And it's their home, which is sacred. Understood.
100%, 100%. Let's talk copyright for a minute.
Okay.
Copyright and photography. There are so many people that that are not understanding that they're licensing a limited license with that photographer, and that when the agent pays for photography, the agent doesn't have the right to give it to the rest of the world. Can you explain to everybody why that is?
So these things are so tricky. So you need to make sure that when you're licensing photography that you understand what that agreement says. So another reason to be like, don't shy away from contracts, because even if you don't have your own that you're handing out, you're going to be subject to certain others, right? So so these photographers sign up with these agencies, and the agencies, license things out, but they, sometimes it's for websites, sometimes it's for social media use. There's all these different types of potential uses. But then if you're if you're if you're licensing it, doesn't mean that you can then give permissions away,
Right.
which gets tricky if people don't understand that. Like you're given permission, you're not
Feeling.
being allowed to give out permission.
Exactly. So this happens most often when the agent pays for photos of the house. And then
Right.
they say, oh, here's the photos. You can just use them, on your website or your marketing or whatever. And it's like, no, 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 you cannot.
Right. Right. So, and so basically, backing up a little bit, the way it works is this: if the photographer, say that somebody hires a professional photographer to take the picture, the photographer may have some sort of agreement with the stager or with the agent, that they can use that on their website or for, in their portfolio or in some way, shape, or form. But beyond that, if there's nothing else, then that agent or that stager is not permitted to pass that along to the homeowner. The homeowner shouldn't, the homeowner shouldn't be using it.
Right.
For anybody else beyond whoever the agreement's with the photographer and somebody else. Because ultimately what it boils down to is the photographer is what's called the author of the work. And so the author retains exclusive rights to do certain things, to monetize whatever it is they've created. And unless they've transferred the rights to that property, meaning like, I don't own it. I created it, but I don't own it anymore. Unless they've transferred those rights either to, an agent or to a stager, then those rights remain with the photographer. So
It's
we make
worth
it
it.
harder than it has to be, but that's pretty cut and dry. That part.
The solution is just so easy because most photographers are happy to relicense it to somebody else and say, yeah, you want to do this? Sure. I took them. You can use it. A lot of the photographers in real estate, they actually limit it to the length of the listing, that once it sells, they're not allowed to limit anymore. And then some of them have gone back in and said, well, can I use it for a website? And they can, pay a fee for that as well. But they're happy to sell you their photography.
Right. I had a case earlier this year where a real estate agent, and this person had hundreds of thousands of followers, and they were posting all different kinds of content on Instagram, and a licensing agency, which is basically a middleman that was managing all these different photographers' portfolios. He was using them unlicensed, the photographs unlicensed, because he had seen other people do it. And there's so many instances where I hear people say like, well, so-and-so's doing it.
Yep.
Why can't I do it? And like, you can, but it's not legal still, for either one of you. Right. So, so anyway, that was sort of the conversation that we had. And he was hit with a demand letter, cease and desist letter, which he came to me over. And I believe it was somewhere in the ballpark of demand was $120,000. Which is not just money that we have in our back pocket typically.
Yeah, it's not chump change.
So we spent a fair amount of time talking about it. And the law was not on his side. The facts were not on his side. So I was really having to dance quite a bit, to try to get that amount down. I did get it down to right around the $10,000 mark, which was significant. But he still, $10,000 is not
Still a lot.
not nothing, so, but anyway, it does have repercussions for sure.
Ignorance of the law is not a defense, right?
No. Ignorance of the law is not a defense, unfortunately.
I would say it's such a drag that
I know.
it seems logical that it might work, but
Yeah. Well, another area that I see happening quite a bit, especially recently, is people have their websites built, they have photography on their website that they've legitimately either paid for or licensed. And then there are these spam sites or scam sites that are basically like mimicking whatever the legitimate site is and trying to divert, the traffic that's going to this legitimate site to this scam site so that the scam site can, somehow receive funds or get them to pay them for nothing, basically, because it's not a real business. And so I'm dealing with a handful of cases now where we're trying to get those sites taken down because they're infringing by using someone else's photography that they've either had taken or that they own or that they're licensing and scamming. So there's that piece of it too that's happening.
Yeah, I've run into seeing a lot of that over the years. And even when you report them to the hosting companies are like, so.
Yeah, it's a real it's almost like whack-a-mole. And so you have to be really vigilant and patient. Because what's happening a lot now too is it's not even companies that are, in our country. It's companies in our country. So that makes it difficult. But I have had success with it. It's just a matter of like, okay, I'm not giving up on this until I get the because I know that the law and the facts are on my client's side. So it's just like, okay, when I talk to the client, like, are you willing to like be patient and let me get this worked out? If you are, then I can do it. But sometimes they're just like, forget it. It's not worth the time and energy. But everybody has to make that choice as a business owner.
Yeah, that's for sure. Well, it's been such a pleasure to talk to you. I cannot wait for your session at RESA Connect. If anybody is on the fence about attending RESA Connect, it is in Atlanta, January 14th, 2025. We're going to start the year off with a bang, and we are going to have a tour of the America's Mart showrooms that are in our RESA buying group. So we're also having an influencer dinner that evening for all the home staging industry award winners and the top 100 most influential people in real estate staging. So we're super excited for that. So if you want to come on out to Atlanta, or you're in Atlanta, you're local, hop on over to America's Mart. Just go to resaconnect.com and register today. Angie, thank you so much. If everybody wants to reach you, what is your website name so everybody can check you out?
So my website is angieavardturnerlaw.com. And I'm on Instagram and LinkedIn, same name.
Excellent. And I pronounced your name wrong earlier, and I apologize. It's Avard.
Avard, yeah.
Avard. I think I put an R in that, but
okay.
Up front. Avard. So that's it. All right. Thank you, everybody. And until next time, everybody, happy staging. Bye.